Good morning. Are you Christopher James?
Yes, ma'am.
And Mr. James was previously in court, entered a plea of guilty to the first-degree felony offense of intoxication manslaughter with a vehicle. I've received the pre-sentence report and also a supplemental memorandum from probation that includes several letters from the victim's family members. Has everyone had an opportunity to review all of that?
Yes, we have, Your Honor.
Are there any additions or corrections to that pre-sentence report?
No, Your Honor, I just want to make the court aware, Mrs. Addison, the deceased's wife, would have been here today to do victim impact. She had to go to the hospital yesterday. She's able to tune in, I believe, and watch us. The rest of Mr. Addison's family is here, and his mother is going to want to do victim impact at the end of sentencing.
Okay, thank you, Mr. Nichols. Any witnesses with regard to sentencing?
No additional witnesses, Your Honor.
All right, Mr. Lewis, you may make argument.
Okay. Judge, of course, this was a very tragic situation that has affected a lot of people. Of course, the decedent, Mr. Addison, his family, as well as Mr. James and his family. It was a situation where, this was a combination of a long substance abuse history of Mr. James. The assessment that's provided in the PSI here says that there was about a 20-year relationship between Mr. James and different substances over a period of time. The one thing I can say is that once Mr. James went through this situation with this accident, he has been doing everything he can to try to better himself. He has got his high school diploma. He's was baptized and has definitely changed his ways in going to his faith and continuing in that regard. He's also got some different certifications that he was able to receive dealing with OSHA. I think it was Men's University, things of that nature to try to better himself, Judge. Now, it's no secret he does have a long criminal history that even included dealing with PCP, which is the same substance that was involved in this accident, and as well as other serious offenses. I do want to address something as far as I know there's some situations here dealing with the jail instances, and I know how the court proceeds or looks at the situation here dealing with those. Mr. James, if you look at these situations, majority of them did come from situations involving him and other inmates, as far as any type of fight or anything like that, which unfortunately some things he can't avoid. But as far as anything dealing with being disrespectful or anything towards jail employees or things of that nature, there's one situation I think that they were talking about that it wasn't an actual write-up, but it was notated. He has been a trustee over there for a period of time at the jail as well. Now, I do want to point out that, of course, some of those situations that Mr. James was able to do to better himself, of course, could definitely increase his earning potential as far as what he has as far as his job situation. He does have significant family support. His brother is here today in the courtroom, who in any way is there to try to help him, including helping secure employment. My understanding is the plan, once he is able to be released, is for him to be moved to Houston, Harris County area, to be close to his brother, to help him with everything over there. Now, PSI did have a recommendation for his different vehicles that support that's available to him through the probation department. What I will say is that everything that has been recommended, he definitely needs and will be better for him. We are not, and ourselves are not asking for a specific number or anything like that. We just want him to be able to, of course, make amends for this situation as much as possible, which could include, which could include some of the restitution there. I think is the amount is over $100,000 for his restitution there to the family. Now, like I said, he has made a plan to try to better himself. He has a family that supports him. He is doing everything he can. He understands that this was a tragic accident, but one he was definitely responsible for. And what we're asking for is as much leniency as possible from the court, for him to be able to move forward with the situation, be able to make amends as much as possible. And I think he did provide a letter to the court as well to kind of speak to that as far as an apology letter that was to the family, his family, the family of the victim, as well as to the court, Judge.
And I've received that.
And so that's what we're asking for today, Judge, is for everything to be considered. We understand this is, you can't bring that person back. He can't just go back to make amends with Mr. Addison, but he wants to try to make as much of amends as he can to society and do better going forward, Judge.
Thank you, Mr. Lewis. Mr. Nichols.
Your Honor, I think any consideration to Mr. James's due was given when he got a 50-year cap. I have no hesitation asking the court to exercise the full 50 years. This case is one of the worst intoxication manslaughters. It's on video where he plows into Mr. Addison, who's at a stoplight on a motorcycle, and while trying to get away, runs over him and the motorcycle again. It's horrific, Your Honor. What is also just inconceivable to me is that a man who's on parole for several possessions of phencyclidine, PCP, finds himself behind the wheel on PCP again. And this time it ends in the death of somebody. His criminal history is extensive. It starts with minor drug offenses, then a conviction for aggravated robbery, and then I believe it's 5 drug convictions all at the same time in 2020, for which he was quickly paroled out and on parole when this happened. The fact that he gets to make plans in his mind for a day he's set free, I find rather offensive, and I think the Addison family finds offensive. They lost a son, a brother, a husband. There's nothing we can do in this courtroom makes that better. And sometimes the justice system is a poor substitute for what people lost. I think the best we can do at this point is this man spend 50 years in prison where he cannot hurt anybody else due to his own selfish decisions and continued use of substances. It's in the pre-sentence report. He minimizes his own addiction, his own dependency. He even claimed he did not know how he could have gotten PCP in his system the day this happened, that maybe he touched a bottle and it transferred through his skin. And I find that reprehensible, Your Honor. And that's why I'm asking the court for that full 50 years.
All right, thank you. So, Mr. James, a couple of things that Mr. Nichols didn't say that I think are also extremely important is this isn't your first driving while intoxicated. This is your third. And so you didn't learn in 2006. You didn't learn in 2017. 2017, you got your second DWI. You were given probation. It was revoked. I appreciate that you entered a plea of guilty because for myself and for the family, I'm glad we didn't have to see what it looks like this would look like on a video, because it is just horrible. And the fact that you are truly saying that you think you touched something and got PCP when you have had PCP cases over and over and over again, and you're on parole for possession of a controlled substance and you kill someone. It's a nightmare. Sure, go ahead.
Can I say something? You know, that night that accident happened, I've been clean the entire time I was on parole. Okay, I stopped off at a friend's house and give him some advice about what he was doing. And during that time, I did contact a bottle of his. You know, I was not high at that time at all.
It was in your
I would take-
system.
Yes, ma'am. If you know how I fight.
At this time, based on your history, based on the nature of this offense, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of intoxication manslaughter. I'm going to sentence you to a term of 50 years in the institutional division of the Texas Department of Correction. There will be a deadly weapon finding based on the indictment alleges a deadly weapon. You will receive credit on this sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement and I followed it, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. There's really so many other things I could say about how horrible this is, and rarely am I out of words, but I really don't have the words to say what a tragic circumstances.
We've reached a critical psychological moment in the courtroom. The judge isn't just listening to facts anymore, they're evaluating credibility. And when a defendant's explanation starts to sound unlikely, it doesn't just weaken their argument, it can define the entire outcome.
Based on your behavior this led to. Y'all can have a seat at council table for the victim impact statement, and we'll go off the record. Do you want me to leave it on for the other family member to hear?
I think that would.
If Stratton Jr.? And so, Mr. Stratton, in cause number 19-33601, charged with capital murder, and this, we're back again on this. Mr. Radford has been appointed to represent Mr. Stratton. And Mr. Radford, have you had an opportunity to get started on discovery?
Judge, I have gotten a transcript. I've got a huge trial docket coming up in the next 2 months, and I haven't had a chance to read it. I have also visited with Mr. Stratton. I've gotten discovery from Ms. I've gotten the paper discovery
Okay.
from Ms. Malfino, and we have visited preliminary,
Easy for you to say.
initially, about a possible resolution to this case that doesn't involve trial, but we're going to have to do some further negotiations, and I think she has to visit with some family members.
Sure. And I know there's probably also some audio, video and things that you need to get.
Yeah, I haven't gotten any.
So obviously, Mr. Stratton is going to take Mr. Radford just a little bit of time to get up to speed on this. And so what I'll do
We've
based
been
on.
working to recreate the file, Judge. It just was in several different places, including the district clerk's possession. I have prepared a written notice asking them for the trial evidence to be returned to the possession of the state.
Okay.
I also have the transcript thing.
I've gotten the
To
transcript.
Ms. Tanner, and we will begin going through that and recreating the file. If there's anything additional Mr. Radford needs, he knows I have an open door.
Judge, could I get 60 days on this?
Well, I was thinking for sure 60.
Yeah.
I mean, I think realistically, obviously, it's going to take you some time to get up to speed, get the file recreated. We don't want to put it off too long. We need to get it taken care of, but I know everybody needs some time. So we're in. We're in September. We're not in August anymore.
I've got 4 huge trials.
Well, so why don't we do this? Why don't we come back first part of December, which is about 70 days, 75
Right.
days-ish. Let's find out where we are. And at that point, if you guys could at least have an idea if it's going to trial, then we can get a special date next year so that everybody's ready and available. And we'll get it set at that point if we need to for trial.
Yes, ma'am.
Okay? All right. Thank you. You can go back with the bailiff. Good morning, sir. You're Brandon Dodd.
Yes, ma'am.
And Mr. Dodd, in cause number 24, DCCR 2418 is charged with murder. What is the announcement?
Your Honor, he previously rejected 35 years. We asked him to stay on the trial docket. We have everything.
Okay. So there's no other negotiations. And Mr. Dodd, we've already gone through what you're charged with, what the possible consequences are if you go to trial. And you visited now with Mr. Burbank and you want to go forward with your trial. Is that correct?
Yes, ma'am.
Okay, we'll get it set on the next available trial docket and we'll see you then.
There is a co-defendant if you want to keep them together.
I don't know that we're worried about keeping them together.
Oh, okay. I
Yeah.
just didn't know if you were-
Okay, thank you. All right, you can go back with the bailiff. And then you've got Traylon Hill. Not for me, for somebody else, unfortunately.
Good morning, Your Honor.
Good morning. How are you?
Doing great.
This could, this is just to go to whatever, do you have the orders on those Burbank's motions? Good morning, you're Traylon Hill.
Yes, ma'am.
And Mr. Hill, in cause numbers 24 DCCR 1500, 1614, 1615, and 25 DCCR 0436, Mr. Burbank has been hired, I believe, by your family to represent you. He has filed motions to withdraw in all of those cases. And so do you have any opposition to me allowing him to withdraw?
No, ma'am, not at all.
So, Mr. Burbank, you are released on all of those cases. Mr. Hill, because you are in custody, I will appoint an attorney today who can begin representing you and get ready for trial in all of your cases. All right, you can go back with the bailiff. Let's see, Mr. Philip Smith on Carrington Scott. Look, I said, because I got used to that yesterday, saying your first name, because we had a hearing with Bruce and Philip yesterday, so I had to.
One way it gets more fun is if the defendant's last name's Smith also.
I know. All right, are you Carrington Scott?
Yes, ma'am. How you doing?
Good. And Mr. Burbank, will your client waive the formal reading of the indictment?
Well, Your Honor,
We're proceeding on the lesser included, Judge.
Thank you. Mr. Burbank already alerted me as well. Appreciate that. Let me get that pulled up the right way. Mr. Scott, in cause number 25 DCCR 0538, the state has elected to proceed on the lesser included offense of a state jail felony theft from a person, and that's from March 20th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
no objection to state's warrant.
It's admitted. Is there any evidence that Mr. Scott is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft from a person. Sentence you in accordance with that agreement to a term of 180 days in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible.
By this point, we've seen multiple cases, multiple lives intersecting with the same system. Different charges, different outcomes, but the same underlying structure. And it leaves us with a bigger question. Is justice about punishment, rehabilitation, or simply maintaining order?
Eligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Burbank.
One other thing.
Yes, sir.
There's a pending felony, misdemeanor, out of misdemeanor court. I don't have it. It's resisting out of this incident, and Mr. Smith said he was going to dismiss it as part of it.
Okay, and so Mr. Smith, you'll take care of that down in misdemeanor court, and they'll get that case dismissed quickly, all right? You can go back with the bailiff, sir. Jody, I'm not sure if I'm going to do this, but for Spanish speakers, non-English speakers, ISF, things like that, do they have accommodations for that? Okay, let me hold this for just a minute because that's something that I'm considering, just based on age and the nature of the offense. If you'll just let them know, we'll pull him back out in just a second. Williams. And Mr. Williams, in cause number 25 DCCR 0176, you're charged with a third-degree felony offense of injury to a child, and that's from October 28th of 2024. What that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that you've signed with Mr. Rojas that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a 4-year term in the institutional division. I'm assuming that would run concurrently with the time that you're currently serving. You have every right to reject that and have a jury here and decide your case. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
I do want to make sure you understand, Mr. Williams, that after today, I will not accept this plea agreement. Once your case is on the trial docket, it'll go to trial, or you can change your mind and plea open to me or plea to something different, but it's not going to be this plea agreement. Do you understand?
Yes, ma'am.
I just don't want you to think that you're going to sit in jail and things are going to get better somehow, right?
Yes, ma'am.
Okay.
Judge, I would also like to put on the record that if he is rejecting this offer that would run CC, the state will file, have this, whatever he receives in this from the jury, to be stacked on top of what he's already received on the interior.
So I do want to make sure you understand, depending on the timeline of all that, there is the possibility that if you're found guilty in this case and whatever punishment you receive could be stacked or run consecutively to that sentence that you already received. Do you understand?
Yes, ma'am.
And do you still want to reject that offer and have your case set for trial?
Yes, ma'am.
Okay, we'll get that done. Mr. Williams, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and appoint someone else today that can begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
So, Mr. Rojas, you are released. Mr. Williams, we will appoint someone today, and they will begin preparation for trial. All right, you can get back with the bailiff. Good morning. Are you Kevin Ross?
Yes, ma'am.
And Mr. Burbank, will your client waive the formal reading of the motion in each case?
We will.
Mr. Ross, in cause number 24, DCCR 1198, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation December 18th of 2024 for the offense of deadly weapon in a penal institution, a third-degree felony, and that was a deferred probation for 4 years. Is that correct?
Yes, ma'am.
It alleges that you, I'm sorry, and then I also have cause number 24, DCCR 1199, also a motion to revoke your unadjudicated probation. This shows that you were placed on probation December 18th of 2024 for evading arrest or detention with a motor vehicle, a third-degree felony, and that was also a 4-year deferred probation. Is that correct? Tell me again why we're doing this.
Just, DPS did bring the video in. They have yet to submit the case formally to be indicted on the evading. So our thought was to allow that to come in, maybe hold it, see how he participates in ISF. Certainly if, based on the circumstances, we need to rediscuss it, we can. I don't believe he's had any write-ups while he's been in. I mean, obviously the new offense was quite egregious.
Well, and that's my, if you're on probation for that and then you do it again, 6 months after you were placed on probation?
No, I would only ask to let him go. That charge is still out there. And then we can address it depending on what the court wants to do, or we come in front of the court again.
But if he pleads on it now, then I don't think even if it's indicted, I mean, if he pleads true today
Right.
to the new offense, and I do what I do on these motions and reinstate and send them to ISF, if the case is then submitted, or when it's submitted, you can't allege the same thing again and then me re-punish him for the same offense that he's already.
It's the new offense that you would address.
But y'all said that today. Count 1 is the new offense.
Right, but
I
it's
can't do it twice.
Well, once it comes back, once it gets indicted, then it can be addressed.
On its own abstinence.
Yeah, on that, not the NTRP, but the new offense.
Well, I know, but then we have 2 probations and a new offense, and the argument then is gonna be, we'll leave him on probation because you can't revoke him because you already did this. Because I already took it into
But you also
consideration
have
on
the
these
option
motions.
of leaving him on probation and then sending him to the penitentiary if he doesn't do well on the new offense. See what I'm saying?
I know, but that's just, I mean,
Would you
any
prefer,
word
Judge,
on
I
where
just-
that is,
that
why
just
they're,
reach out to them again? I know last time it was kind of in the context of that conversation. If you
yeah,
don't want me to call them, you're gonna call them.
yeah.
I can do that, and I can get it to grand jury by next Wednesday.
I just would like more information, I think, before, on that case. I don't
Right.
think we need to have them on a probation, and then those out there pending, and then in the middle of ISF, they send it. If a warrant's issued, they're gonna kick them out of ISF anyway.
They were gonna hold it until he got out, Judge.
I'm gonna reset it just a short time. If you will reach out, or if I need to reach out, I understand, I appreciate that they, I guess, cooperated somewhat with getting the video, but I think I'm gonna look into that a little more myself and find out where it is in the process and why it has not been
Yes, ma'am, because
submitted.
the offense date is June 13th.
Yeah, that it makes no sense to me. And from what I recall, it was not just a couple of blocks going slow. It was, okay,
I'll have investigator Bates reach out this morning, and we'll get it indicted by next week. If maybe an update would be beneficial.
that's what I'm thinking. I think I'm not gonna just automatically do it. I think if there's gonna be pleas, we can do an updated PSI. I wanna know more about everything that's been going on before I agree to something like this. All right, you can go back with the bailiff. Would you? All right, this is cause number 25, DCCR 0304. And are you Gerson Santa Maria Mendoza?
Yes, ma'am.
Mr. Mendoza was previously in court, entered a plea of guilty to the first-degree felony offense of aggravated robbery. The agreement was for a 10-year deferred probation. and a $1,000 fine. I've received the pre-sentence report. And has everyone had an opportunity to review that report?
Yes, Judge.
Are there any additions or corrections?
No, Mr. Davis.
No, Mr.
So, Mr. Mendoza, you're only 18, is that right?
Yes, ma'am.
All right, so if I'm going to follow this agreement based on your age, the nature of the offense, the fact that you withdrew from school and haven't completed high school, I'm going to up front send you to the program called ISF. It's a 90-day program, and it is intended to help you to make better decisions. Because of your age, obviously, I want you to be successful on this probation, but I think there needs to be some involvement by other people to help you do better. Does that make sense?
Yes, ma'am.
So I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You're ordered to pay the $1,000 fine and follow all of the rules and conditions of probation. That's including going to and successfully completing the cognitive track of the ISF program. If you do everything you're supposed to on this probation and you successfully complete it, this is a great opportunity because you don't have a conviction for a felony on your record. The other side of that, though, is if you violate any condition of your probation, you can be brought back into court, found guilty, so you would be a convicted felon, and you could go to prison for anywhere in the range of punishment, which is a minimum 5 years, up to the rest of your life in prison. Do you understand? Also, a condition of your probation is going to be that you get your GED. So once you get out of ISF, you're ordered to start that process within 45 days. Okay. All right, I'm handing you the trial court certification. That shows that this was an agreement that I followed, so you waived your right to appeal. Okay, good luck to you, sir. Thank you, Ms. Burge. Thank you. All right, sir, are you Robert Isaiah Paredes? And Mr. Paredes, best you can, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. And so, Mr. Kimler, will your client waive the formal reading of the motion in each case?
You will.
Mr. Paredes, in cause number 16-24053, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation November 14th of 2016 for possession of a prohibited weapon, third-degree felony, and that was a 10-year deferred probation. Is that correct? Cause number 20-35329, I also have a motion to revoke your unadjudicated probation. This shows that you were placed on probation March 7th of 2022 for aggravated assault causing serious bodily injury, a second-degree felony, and that was also a 10-year deferred probation. Is that correct? Yes, ma'am. And then finally, in cause number 20-35328, I also have a motion to revoke your unadjudicated probation, Shows you were placed on probation March 7th of 2022 for aggravated assault causing serious bodily injury, a second-degree felony. That was also a 10-year deferred probation. Is that also correct? Each of these cases allege that you violated your probation. Count one in each case alleges that you failed to enter and successfully complete the JCDI program. Is that true or not true?
True.
Count two in each case alleges that you provided a urine sample June 12th, June 24th, July 10th, and July 31st that tested positive for tetrahydrocannabinol. And is that true or not true?
True.
THC or marijuana?
True.
Okay. Count three in each case alleges that you provided a urine sample July 31st of 2025 that tested positive for cocaine. And is that true or not true?
True.
Count four in each case alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
True.
You sure?
Well, I did two right before the month before I turned myself in, so
2 hours?
I did 2 days.
Two.
They said they were gonna give me about 13 hours a day.
I think just plead not true to that one.
Yeah, it should have been about 25, 26 hours.
Okay. We'll do not true for that. Count five in each case alleges that you failed to submit to alcohol or drug screening as ordered June 18th, June 25th, July 2nd, July 5th, and July 21st as ordered. Is that true or not true?
Not true.
Okay. Count six in each case alleges that you're behind in your court-assessed fees. Is that true or not true?
True.
Did you enter your pleas of true in each case to counts 1, 2, 3, and 6 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
All right, then each of your cases, I'm going to find that you entered your pleas of true to counts 1, 2, 3, and 6 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to find you guilty and revoke your probation. However, I'm going to reset your case so that the probation department can do an updated pre-sentence report. That'll give me more information about you, your probation, what's been going on. Also, at that hearing, if the state has any evidence with regard to those other counts, they'll be allowed to put that information on. Anything that you think is important for me to know, make sure you get that information to Mr. Kimler. He will present it to me on your behalf when we come back. These are unagreed. They're, so let me make these notes and then. Brittany's mad. There's those. All right, so Mr. Kimler also filed a request that I set bonds in these three cases. There are currently no bonds set. Is that correct?
I believe so.
Mr. Kimler, you may proceed.
Your Honor, I appreciate the fact that these are serious cases, 2 ag assaults and serious bodily injuries, and a prohibited weapon, which I believe was a short barrel firearm. I don't know whether it was a rifle or a shotgun, which I guess at first glance would be indicative of somebody's potentially dangerous to the community. I could only observe that the evaluation by the state, the probation department, and I suppose the court of these cases initially was that they were more worthy of deferred adjudicated probation. The finished performance on probation has not been sufficient. He's fallen short. I would observe that there are no allegations of a new offense, but he has been remiss in taking care of his obligations. I don't know that he appreciates really the seriousness of what he's looking at in the event of a revocation. I could say that because he was somebody that's facing 20 years in penitentiary on an aggravated offense, that can't refrain from the use of marijuana or THC, probably isn't taking their probation seriously, and doesn't fully comprehend the severity of what he's facing. I would ask the court to set bonds in these cases at an amount, hopefully, where he can meet those bonds in order to get out of jail and demonstrate to the court during the time period the court is waiting on the updated pre-sentence report that he can get back on track or get on track with his probation and hopefully perform a community service, do whatever evaluations that are necessary, and demonstrate to the court that he can refrain from the use of illicit substances. Really, it's kind of an opportunity for Mr. Paredes either to demonstrate to the court that he has the desire and ability to complete probation or not, and he comes back to the court in 30 days and hasn't done anything on probation, then obviously the court would take that into consideration. It could revoke him, give him up to 20 years of the penitentiary on an aggravated offense. So it's really would be up to him, and I'd like him to have that opportunity
Well,
on bond to come back.
let me just stop you because Mr. Paredes has had every opportunity. Mr. Paredes was on probation for that prohibited weapon case, placed on probation in 2016. Then we have 2 new aggravated assault causing bodily injury indictments while he's on felony probation, and for whatever reason got another opportunity on those 2 cases at a deferred probation, has been given every opportunity. There was an MTRP filed. He wasn't revoked before. He was given probation, a deferred probation, which probably I did deferred on those so that if he did continue to violate, that I would have the entire range of punishment. If I had to guess, that's probably what my thought process was. Given an opportunity at JCDI where he was unsuccessfully discharged, where they're trying to help him with all of these things, I think based on all of that, the underlying offenses, the nature of the aggravated offenses, the fact that the first one had to do with a prohibited weapon, I do not think it is in the best interest of our community while he's out using cocaine, marijuana, getting kicked out of JCDI and on probation for these serious offenses, that he be given a bond at all. And I am going to find, based on the criterion 17.15, that it is not in the best interest, that even though this is a deferred probation in each of these cases, because there's 3, because there's 2 aggravated, that it is not in the best interest of anyone that he be granted a bond in any of these cases. There will be no bond in all 3 cases.
Yes, Your Honor, I would just urge in conformity with the motion that I filed for a speedy revocation hearing, that since the court's denied bond, we have a hearing, a dispositive.
We just had yeah, I mean, he just pled true, and so we'll get the updated report and get it set immediately after that.
I think it, Article 42A embodies an idea that there'll be a dispositive hearing within 20 days if the bond's reduced. That's my reading of it. So we would need to get an expedited PSI if there's denial of bond. That article, it's in the motion, the 20-day requirement if a bond's denied.
All right, let's get okay. All right, we'll get it set
He's gonna
in
be
3
sitting
weeks.
there.
We'll set it for 3 weeks. Go back with the bailiff.